Good morning, everyone. Welcome. We're here today with the Printing Industry Midwest, along with Tom Revnew from Littler, and we're going to keep this pretty loose. It's a round table. Tom is going to share some slides to get the conversation started. I'll be monitoring the chat. Um, as well as once he's done, we'll just open it up for questions, comments, concerns. Like Tom said, we might be learning from each other today as well. So this is just kind of a space for all of us to talk about um, uh, what's going to happen here soon. And I will turn over to Tom Revnew.
Hi, good morning, everyone. As Chris said, I'm going to cover just for background. Some of this I think is going to be information that, some of it may be new. But I just thought to kick this off, I would just quickly review, what the Minnesota paid family medical leave law requires, and then just we'll open it up this is a roundtable more than anything, but I just thought it'd be helpful to cover these slides, and I'm going to cover them pretty quickly. This is not a deep dive as far as the PFML, given the nature of today's roundtable. But as you know, if and maybe you don't, that Minnesota is the 14th state to implement paid FML. So there's quite a few states that have already implemented it, and the state agencies are drawing from the experiences in these other states so that they can set up their program based upon some of the learning lessons in these other states. So the question becomes, what leave is protected? And I think everybody knows that there's really two types of leave. There's paid family leave and paid medical leave. And each type of leave will allow for a 12 weeks of duration. But between paid family and paid medical leave, an employee cannot take more than 20 weeks of leave in the qualifying year. And of course, when we start talking about family leave, you have to take a look at who is defined as a family member for purposes of family leave. And it's broad, but it's not as broad as earned sick and safe time. So Minnesota's paid leave will include the spouse and domestic partner. It also includes children, whether it's a biological, adopted, foster, or a stepchild. And of course, parents or legal guardians are part of the family membership, along with a sibling, a grandchild, a grandparents or the spouse's grandparents, a son-in-law, daughter-in-law, and then an individual who has a relationship with the applicant that creates an expectation of essentially a family relationship. By now, hopefully everybody knows that DEED is administering the program, and the benefits will generally be paid by the state to individuals, unless, of course, as an employer, you elect to do a private plan, which I'll cover very quickly in a little bit. But the benefits will be considered taxable income under state law, and you as an employer will get to define what is considered a benefit year. And of course, questions become, when does an employee get to use the PFML? Well, it has to be a qualifying condition that lasts more than 7 days, and it needs to be certified by a healthcare provider or designated professional. DEED is responsible for preparing the draft certification. I don't think I've seen one yet. I think what is going to be interesting as PFML is rolled out is foreign providers may certify medical conditions. So if you have a workforce that has employees that originated from other countries, they can use a provider in their native country to provide or certify that they have a medical condition, and we'll have to rely on that certification. And then, of course, with regard to intermittent leave, employees can take intermittent leave under the Minnesota paid family medical leave. The intermittent leave must be taken in increments consistent with the company's established policy, so long as the company's policy permits a minimum increment of at most 1 calendar day of intermittent leave. And of course, everybody on this call is more than likely covered. So I won't get into that. I think everybody on the call has more than 30 employees, but if you have less than 30 employees, you might qualify as a small employer, and you'll have an opportunity to get assistance to comply with the paid family medical leave. And then, of course, which employees are covered? Well, it's pretty much all employees are covered under the paid family medical leave, whether they're full-time employees, part-time employees. Most seasonal employees are covered, as well as owners or officers. Temporary workers are covered. And of course, the temporary workers are going to be covered by the temporary help agency more likely than not. There are some employees who are not covered. So if there might be an independent contractor that works for you that would not be covered, certainly an independent contractor, and that has a specific definition and that I'm not going to go into just in the interest of getting to the roundtable, but an independent contractor would not be covered, but they can opt in. Same with regard to self-employed individuals. And then, of course, there are some that are not covered that cannot opt in, which isn't really germane for today's call. And then, of course, some of you may have multi-state operations, and there is a test to determine who is eligible to participate in the program. So paid leave covers Minnesota employees, and the paid leave law defines a Minnesota employee as someone who works 50% or more of the prior year in the state of Minnesota. And then you have employees who did not work 50% or more of the year in any one year, but they live in Minnesota. If they spent at least 30% of their time in Minnesota and they're a resident of Minnesota, they're going to be covered if, let's say you have 3 states, Minnesota, Iowa, South Dakota, and they live in Minnesota, they're going to be covered under Minnesota law. I've been getting a lot of questions on this that, hey, I have employees that mostly live in another state. Are they covered? The answer would be no. I've had questions that I have employees who work exclusively remotely from another state. Are they covered? And the answer is not. I've had the question of, my business is located in Nebraska, but some of the employees I hire live in Minnesota. Are they covered? And it's really going to be dependent upon where those Minnesota residents are performing their work. So real quick, what's going to be required of employers? You're going to have a payroll deduction, premium payment, wage reporting. When we get closer to implementation, you'll have to post a workforce poster. You'll have to notify employees of their rights. And then, of course, we'll have to have somebody that helps coordinate the leaves, the PFML. At this point, I would hope everybody knows that you know that your wages will have to be reported once per quarter. Effective January 1st of 26, you can start deducting up to 50% of the premiums from an employee's paycheck. And as I said earlier, employers with 30 or fewer employees may be able to get a reduced premium. So essentially, what that means is based upon a starting premium of 0.88% of the employee's salary, which I think is going to change. You can see that the maximum employee weekly contribution would be $14.90. Maximum weekly benefit under the current rates for an employee would be $1,372. And then, of course, on this slide, you can see that there's a reduction for a small employer, which has a reduction in the contribution rate. And then, as I said, you have to inform your employees. So you'll have to hang a workforce poster informing them of their rights, and you'll have to notify employees of their individual rights, and that takes place in December. And again, I'm covering some of this pretty quickly, but ultimately you're going to have to determine who's going to be your leave administrator for purposes of the Minnesota PFML, as well as how you're going to handle the Family Medical Leave Act to the extent that you fall under it. And then, of course, you have to address the Minnesota Parental Leave Act as well. And of course, there's going to be an administration headache trying to coordinate all these different laws with regard to the Federal Family Medical Leave Act, the Paid Family Medical Leave Act, and then, of course, Earn Sick and Safe Time. And we'll open this up for discussion in a little bit. But as you know, the leaves can be taken concurrently if it's for the same purpose. And you can require, as an employer, if you fall under the Federal Family Medical Leave Act, you can require that they take FMLA and PFML concurrently. However, you will not be able to force your employees to take earned sick and safe time. And of course, there's a side-by-side comparison of what does earned sick and safe time provide, what does paid family medical leave provide. I'm not going to go through each of the points on here just in the interest of time. And then, of course, we have the qualifying reasons for earned sick and safe time are going to be different than the qualifying reasons for Paid Family Medical Leave Act. Some of the differences may be that somebody can take time off for a school closing under earned sick and safe time, which would not qualify as a reason for taking time off under the Paid Family Medical Leave Act, as well as bereavement, which you can take under earned sick and safe time, which would not fall under paid family medical leave. I'm not sure if there is anybody on this call that is signatory to a collective bargaining agreement, but keep in mind that with regard to how you handle paid family medical leave, you will have a duty to bargain with your employees or with the union with regard to how you're going to administer paid family medical leave, and that can include whether the employees will share the premium with you, and of course, you're likely to have a duty to bargain over whether you're going to use the state plan, an insured plan offered by an insurance carrier, or whether you self-insure for purposes of paid family medical leave. And of course, once we have federal paid family medical leave, it will have an impact on other benefits that you provide as an employer. It certainly would have an impact on short-term disability benefits that you offer. It may also have an impact on your paid time off or vacation policies, which you'll have to consider how those other benefits are going to be impacted by the paid family medical leave law, whether you're a union employer or a non-union employer. But if you're a union employer, you're going to have a duty to bargain over any changes that you are making to those benefits. And then, of course, you hear about you can, in lieu of going through deed, adopt an equivalent private plan. As I said before, an equivalent private plan is either a product that's going to be offered by the insurance carriers or a product that you design yourself, and it's essentially a self-insured product. But the bottom line is, if you do decide to go down the path of a private plan, and I'll be interested in hearing when we get to the roundtable whether anybody has explored this yet and where you're at. But essentially, if you go down the path of a private plan, you're going to have to meet all your obligations under paid family medical leave under that equivalent plan. So it's got to at least meet, but it could exceed the coverage offered by the state plan. And the equivalent plan must meet or exceed coverage for leave that's available to current and recently separated employees. It needs to consider payment rates to employees on leave, as well as make it clear that the employees are entitled to job protection. So some common questions or misconceptions on equivalent plans. I just want to make it clear that with regard to a generous short-term disability plan, that in and of itself would not comply with the private plan requirements. A 12-week paid parental leave policy is not enough to comply with the private plan requirements. Providing as much paid leave as a state program does not ensure your private plan is compliant. And so there's a whole host of things that if you're thinking about going down the path of creating your own plan, a self-insured plan, you actually have to get approval by the state. So what the state has told us thus far is if you do have a private plan, all of your employees will have to be covered under the equivalent plan. The eligibility requirements cannot be more restrictive. The weekly payments have to be at least equal to the state plan. Certainly you could have more. The total weeks available must be at least equal to the state plan. And if you do have a private plan, the cost to employees cannot exceed what their cost would be under the Minnesota paid leave law. And of course, the equivalent plan must cover any serious health condition or medical care that would be covered under the state plan. And that's the same with regard to family leave. The equivalent plan must cover the same type of care for a family member, and the equivalent plan can't impose any additional conditions or restrictions on the use of leave. So the bottom line is that when you go down the path, if you do go down the path of adopting an equivalent private plan, that plan will have to be approved by the Department of Commerce. So if you're looking at a product through an insurance carrier, the insurance carrier will be getting their plans approved by the state of Minnesota before they can offer them. And if you go down the path of adopting a self-insured plan, it's the same thing. It's got to go through the Department of Commerce and be approved. And of course, those plans have to make it clear that the employees won't be retaliated against as a result of seeking or requesting benefits or exercising their rights under the Minnesota paid family medical leave law. So I think one thing just to keep in mind is for this year, we're still waiting for a lot of the rules to be adopted by the state. We have some rules, but there's more to come. And the deadline that I think you have to keep in mind is you're going to have to notify your employees about the paid leave benefits by December 1st, 2025. And then finally, just to cover a couple things, certainly between now and January 1st, you need to look at your existing leave policies and determine how you're going to coordinate your existing leave policies with the Minnesota paid family medical leave. You'll have to consider whether to apply for a private plan or use a insured product. And of course, hopefully you're working with your accounting department to ensure that they're prepared for the upcoming additional payroll taxes. And you're working with your payroll administrator or your payroll folks to make sure that you have the appropriate infrastructure in place to support the PFML and amend the employee earning statements, because you will have to put on the earning statement the fact that you're making deductions for PFML. And then, of course, unfortunately, yet once again, you'll have to review your handbook and your policies and identify what changes need to be made to ensure that you're complying with the state law, as well as coordinating with the federal FMLA. And of course, we're still waiting on clarifying rules. So a few more deadlines here. Your first premium payments will be due April 30th of 2026. That's when you'll make your first payments. So again, I covered this relatively quickly. I just wanted to get the roundtable started, give you some things to think about. And I'm going to turn off my slide and we'll start the roundtable.
So I actually reached out to Unum, who is our STD provider, and asked them if they could give me a quote. That was about a month and a half ago. Could that be partly because things aren't settled here yet?
Yeah, I think so. I talked to a client on Tuesday and they were working with a broker. And it's the first time that I had heard this, but they said they were getting quotes from their broker. Actually, they were meeting with their broker today with quotes, which surprised me to hear that. So I don't know whether it's a formal quote or just an estimate. And I am curious whether anybody has reached out to any other providers to get quotes or look at the insured plans.
And I do have one other question because when I read the stuff from the state regarding quotes, it looks like to me that if you did keep it through a carrier, they're not paying it out. I mean, it looked like to me that they're following the state model and the state's paying it out still. I don't know. I found it very confusing how they explained what an employee could receive from the state.
So that would really surprise me. I have not heard that, and I'm not disagreeing with you, but
Oh,
my understanding is that it's an insured product and that the insurance carrier would be making the payments.
okay,
And I do know that's how it is done in other states.
okay.
So, there are a number of states that allow employers to have an insured plan, whether it's New York or Colorado. And my understanding in those states is the insurance carrier is actually paying it out. They're
Okay.
the
It's
ones.
just how they presented it. It wasn't clear. It it was like, I don't really understand what you're telling me.
Yeah, well, I hear you, and I think they're still trying to figure out what everything means as well.
I think you're right. 100%.
I think one thing that, folks may be thinking or wanting, which is, gee, I thought this was going to get postponed for a year. And if you didn't know, I mean, there were a lot of people that were asking me this in April and May, even in June when we had the special session, because the Republicans were trying to push for a 1-year delay. And I had a few lobbyists that told me that was priority number one for the Republicans, was to get a delay of the paid family medical leave law. And obviously, we do not have a delay. The law will take effect January 1st. And then anecdotally, I've heard, in other states, when they've set up the paid family medical leave, it's taken a lot longer than what Minnesota is trying to do. So I think there's going to be a lot of hiccups when we get to January 1st.
You mentioned small companies. What is the size? What are they consider small companies?
30 or fewer.
Okay. I also, there was something at one point about owners having to register with the state or do fill out something prior to this starting. Because they're not covered under unemployment.
Yeah. Um, and Marla, you know probably more than I do on that.
Okay.
So, I mean, we're drinking from a fire hydrant, and for purposes of today's roundtable, I don't want to represent that I know each and every nitty-gritty detail as to the paid family medical leave law. I've certainly read a lot about it and I've presented on it, but it's so new and things are being developed that I just don't have all the answers, and and the rules haven't been adopted. But you're right. There was an issue with regard to, because the owners would be excluded or could be excluded from paying the payroll taxes that you would have to report for PFML.
Mhm. You're not the only one that doesn't know the answer to that question.
Yeah, the state probably doesn't know the answer to that question.
That's true too.
So having said that, I assume that there's going to be quite a bit of grace at the beginning of this thing.
Boy, I would hope so. I just can't imagine that there's going to be a lot of ramifications when the state uh, doesn't have all the answers, right? I think it will be as we get closer. I think what the state's going to be looking at is, are you trying to comply in good faith? And I also think that if for some reason there's a mistake that's made by an employer based upon the state's interpretation of the law, that you're right, there's going to be some grace. They'll say, hey, this is how you fix it going forward.
You also mentioned the fact that we have to pick a leave administrator. Like for FMLA, we don't have a leave administrator. We kind of do that internally. But for this, we have to have an administrator that isn't us.
No. Sorry and again, I was covering it fairly quickly. My point was more internally,
Oh.
who is going to help administer PFML, right? Because you're going to have somebody that is a point person for the employee.
Yep. Okay. That makes me feel better.
And I think I frankly, I think even if you do an insured product, you're going to have somebody that is
Oh, sure.
the coordinator, right? Because the employee still has to notify you that they want to take leave,
Mm-hmm.
right? And either way, we're going to get them the information. Okay, well, here's how you apply.
Yeah. So if we do it just through the state, basically it's just a coordination between the employer, the employee, and the state.
That's
Correct?
right. That's right. And it would be the same with an insurance carrier, right? The coordination. And here's my off the cuff thought with regard to an insured product versus a self-insured product versus the state. I think that number one, I don't know that we're going to have enough information to determine whether or not to go insured versus going through the state by January 1st.
Mhm.
I think we'll be pushing it, right? And I don't know that the carriers are going to be able to give good quotes between now and the beginning of January. I could be wrong. I think as you're deciding what to do in the future, whether it's next year or it's for the 2027 year, I think one thing you have to look at is who's going to do a better job of administering this program? Is the state going to be better equipped, or are we as employers better equipped, or is the insurance carrier better equipped to administer the program? And I can't answer that question for you. I think there's a little bit of a political uh, bent as to how you answer that question, because some people will say, well, I don't like how the state administers the unemployment system, so I certainly am not going to like how they administer paid family medical. But ultimately, it's going to have to be a business by business decision on what makes the most sense. And of course, ultimately, it's going to be the cost versus the benefit of going to an insured or self-insured product.
Okay. And then I did, and you said that the max contribution from an employee is capped at 1490.
Well, that was an example based upon, and I can pull that slide up, but essentially their payroll tax is capped at 0.44%.
Okay, so it can't be. Okay.
So if I'm understanding that slide correctly, it was 0.88 is the total amount for an employee's premium. But they're only required, the max the employee can contribute is 0.44.
That's right.
Right.
So an
Oh.
And then-
employer could do
and then-
anything in
And
between.
then in addition, there is a cap with regard to the amount of wages that are subject to that payroll tax. So just like Social Security, you have a cap that you're going to contribute up to a certain threshold of your salary. And once you hit that salary threshold, you're not going to contribute more than that. That's the same with regard to the total amount. And so it is, I had to think through the question as it was being asked, but yeah, so the maximum weekly employee contribution would be $14.90. I don't know what that
Okay, so that is the cap.
under existing numbers. So
Okay.
that could change in the future. But using what we know today as far as what the amount is, yes, that is right.
Okay, all right. Somebody actually did ask me if it was like Social Security. So it is the same.
It is, and I don't remember what the number is. I can see if I can find it while we're talking here, but there is a cap.
Okay, that makes sense.
Yeah, it is actually, it is the Social Security taxable maximum is what they use.
It's the same?
It's the same. Yep.
Right now.
Right.
So this is kind of a strange question. Does the state have until December 31st to make changes, or is there a cutoff date that this has to be finalized?
As far as changing the premium,
As far as changing any of it?
well, so that's a great question. And there's a couple things you have to consider. So first, we have a state law, and any amendments to the state law have to go through the state legislature and have to be signed off by the governor. So if there's a state law change statutorily, then it's not going to happen this year. Okay. Secondarily is the state agencies have been given rulemaking authority. And so they can adopt rules as to how the law is going to be administered and be applied. And so they are going through the rulemaking process right now. And so as to how the law will be administered, they are issuing clarifying rules, or will be issuing clarifying rules. So I would say that the clarifying rules may be interpreted as a change, and the agencies would say, no, we're just we're clarifying what the law requires. So hopefully that answers your question.
I think so, yeah.
And I do expect the tax rate to change. I think, ultimately it will change as we go into the future, but I think that 0.88 you can rely on until the legislature gets back.
Do you think
I
it'll
don't-
go up or down?
It'll go up. I think you have to anticipate that it's going to
Hey.
be double or triple the cost of what they are projecting right now. I mean, think about this. So the state is promoting that they're the fourth lowest payroll tax in the country for paid family medical. And yet the benefit that they're offering is going to be substantially more than the benefit that is offered in other states, because Minnesota will offer 20 weeks of paid family medical leave, up to 20 weeks of paid family medical leave. I think most states are at 12. So I'm curious, has anybody else talked to a broker? You guys are awfully quiet today.
Well, and I didn't talk to a broker. I talked because we have a short-term disability policy that we pay for
Yep.
for everyone. So we were trying to figure out, does it make sense to keep it
Yep.
and go through them? That's the only reason why I talked to him and I asked him for a quote.
Sure. And I think the other thing to keep in mind is that once paid family medical leave comes into existence, so let's assume that you decide, yeah, I'm going to go through the state plan. That state plan may not provide the benefits that your employees receive or would receive right now if they were getting short-term disability. And so if you kept your short-term disability plan, they're not going to give 2/3 of the benefit, right? They're going to take 2/3 of the benefit less whatever is offered by the state. So I think you have to look at other types of plans that these short-term disability providers will provide. And one benefit would be, well, the carriers have a top off plan, which will allow employers to get a benefit that tops off that which is being offered by the state paid family medical leave. So it's not a full short-term disability, it's a short-term disability light because everything
Right.
else is going through the plan.
That's actually what they did describe to me. because it's the higher wage earners that won't get as much from the state. So they're gonna fill in that gap.
Yep. And somebody, oh, go ahead.
This is Barb from Streamworks. We also talked to our broker and to Unum, and we're looking at that and have met with our broker. We also are exploring a coordination of the benefits because Unum does our short-term disability as well. So we just did a demo yesterday on that.
And how
Barb,
was
did you?
it?
It was very interesting to us. We have ADP and carrier connections. So for us, what was really intriguing is that all of the information would already flow through. We use Unum for short-term disability and other products. So a lot of the administrative pieces we would not have to do because it would go back and forth. And then we were looking at the private insurance piece and with that top off product. They are administering in other states. So that was intriguing to me that they have some experience.
Do they have a product that's approved yet by the state? Or don't you know?
They were talking that I believe it was approved or it's close because they were talking about opening it up in July and giving us the forms to fill out.
Okay.
Well,
Giving you the form so that you could get a quote.
They gave us an estimate quote similar to your what has been mentioned, and so we don't have. I guess we do have a firm quote. I take that back.
Oh, you have
And
a
then they
firm
were looking at and they were reducing our short-term disability amounts because it was going to be that top-off program and would be that coordination.
So Barb, I think everybody's wondering, so I'm gonna ask the question directly, which is based upon what you're seeing, if you did the top off, well, sounds like maybe
It
you're
was
looking.
less.
Okay,
It was less than the state, and it did help reduce the short-term rates.
so you were looking at Unum providing a product that would cover the company for paid family medical as well as
Yes.
a top off,
Yes, and coordinating it.
and it was less than the state.
Correct. But we've been with them for short-term and long-term, so they were looking at our experience there as well.
Okay. Well, you're the first positive news I've heard on this front, Barb, so thanks for sharing.
Just out of curiosity, how many employees, Barb?
150. Now, the question that I didn't ask that I should have asked is if it's going to be on experience rating and if the state is just on like a flat increase. So we're going back and asking that.
That makes sense.
Yeah, that's a great question, Barb, and obviously keep in mind, as I said earlier, you will not be able to charge the employees more than what the state permits you to charge. And I assume that there's going to be a premium co-sharing with the employees.
Yes.
Well, what other questions you guys have on paid family medical?
I think I think we're pretty good. Like, I also asked the group, like, I think I explained that Tom probably wouldn't know a lot of immigration answers, but he could maybe take questions and pass them along to someone in his firm that might have some knowledge, but no one sent me any questions. I don't know if anybody on this call was here to ask questions of the group. It doesn't sound like that.
So,
Go ahead, Tom.
and I was just gonna anecdotally share that there are ice raids going on in Minnesota. I'm aware of at least two, if not three. Uh, one down in Rochester, one down in Burnsville, with regard to unauthorized workers and raids being done by Homeland Security. I don't know a lot about, what has transpired yet. I probably have more information in the next few days, but they are actually in Minnesota. I have not seen yet an uptick in I-9 audits. That's not to say that they haven't happened, but as you remember, under the first Trump administration, there was a significant uptick in I-9 audits, and I think we'll get there in the near future. And then one thing before I forget, I just wanted to, if you're not aware, the state has been rolling out educational webinars on paid family medical. They've been doing them I think on a monthly basis, and some of it is on basics, some of it is on the type of plan, whether it's an equivalent plan or not. And I know they just had one on third-party administrators, the third-party administrators administering paid family medical in Minnesota. But there are some educational webinars that are being done by the state as well that um, they're trying to at least get information out as they know that information themselves.
Is there anything else? I will remind everyone that our next HR Huddle will be on July 24th at 11:30. It's remote for everyone. Hoping Tom might be there if there's any questions that move along in the month or we see what's going on. He'll be available. We are also so our guest for that will be a connection with Paylocity because that was one of the suggested topics of coverage. And PIM as an organization might be working with Paylocity to offering a group buying program for our PIM members. And so she will be presenting at that meeting as well. More details soon. It's not even up on the events page yet, but just thought I'd give you guys a heads up.
And since you raised the next meeting, Chris, it dawned on me that since this is the HR roundtable, I want to make sure that it's on your radar that there were a few changes in employment laws that took effect in Minnesota. First and foremost, and I think this is a huge issue for Minnesota employers, and I think it's flying under the radar. But Minnesota became even more California-esque after the special session because a bill was signed into law on last Friday by Governor Walz that essentially says that in Minnesota, you have to provide, well, you already have to, but let me clarify why there's a difference. You have to provide both a rest break and meal breaks. And two things happened with regard to the amendment to the law. One is with regard to rest breaks. You have to provide the greater of a 15-minute break or the time necessary for the employee to use a restroom every 4 hours. So minimum 15-minute break every 4 hours. And if you fail to do so, if you fail to provide them with a break, they can get damages for the lost break, plus liquidated damages of an additional 15 minutes. And of course, you may think that's not that big of a deal. We're going to give them breaks or not, but in California, there's a lot of litigation over rest breaks and meal breaks and whether they got them and whether they were denied the opportunity to get them. And then secondly, with regard to meal breaks, the law changed from you have to give them sufficient time to take a meal break to you have to allow them to take at least a 30-minute break for meals, which coordinates with federal law so that it's unpaid. But if you fail to provide them with a meal break, they get the meal break as well as liquidated damages of an additional half hour. And in California, we've seen a lot of class action lawsuits about employees being denied breaks. So those provisions take effect January 1st of next year. We wrote a short article on this that was published in the last day. And then there are additional changes with regard to earned sick and safe time. Some good changes, some bad changes. And we haven't put an article together on the earned sick and safe time changes, but some of the changes include that one, you can ask for documentation if the employee has missed more than 2 days of time versus more than 3 days, which is current law. The earned sick and safe time changes, I believe, also take effect January 1st of next year. And then you'll be able to essentially estimate and front load a portion of the earned sick and safe time for employees that are hired in the middle of the benefit year. So those are a couple changes that took effect with earned sick and safe time, and I'm sure you're going to see plenty of articles on all these different changes that took place this last legislative session. But like I said, Governor Walz just signed these bills into law last Friday, so I think you'll start seeing articles if you haven't already, certainly by next week.
And Tom, if you have those articles, if you can share them with us, I'll have Sadie put them in our e-loop. So
Sounds good.
they can be on the lookout for that.
Sounds good.
Sounds good. All right. Well, go ahead. Oop, someone say something? No?
I had
Oh.
2 questions.
Oh, go ahead. I'm sorry, Barb.
Tom, do you recommend then that we document when people are allowed to take their breaks, like on our ERP, that they just clock in, do something that shows that we offered it, or
Yes, absolutely.
I'm risk
I mean,
averse?
yeah, no, I agree. And I mean, the Department of Labor and Industry has rulemaking authority. I hope that they come out with some rules that clarify how these are going to be rolled out. But I can tell you, like, I mean, you have employees that'll say, hey, I want to work through my lunch. Because I want to go home early, right? And that may not apply to some of your businesses, but others it will. And of course, what if, you know, the question will be, can you have essentially what's referred to as a meal break waiver so that the employee can agree that they're going to waive their right to a meal. And in some states, they've adopted that. So like California or the state of Washington, as I understand it, if you don't have the meal break waiver signed, it is essentially presumed that you denied them the opportunity to take that meal. So I think we're going to have something like that in Minnesota. And Barb, to your point, yeah, do I think you should document? Absolutely.
Wow.
And then my other question was with this ESST time and what they passed, that if you have everything in PTO, all of that counts as that ESST. Are you still recommending that it was split out, that your PTO is the smaller bank?
I am,
matches?
yep, I am, because they did not change that. They did not change that law.
Okay,
Yeah, that was something that we're hopeful that they would fix, and they did not fix that, so that law is still the same. And then one other change, which I don't think is a big change, but for unforeseeable leave, if the need is unforeseeable, the law currently requires that the employee give you notice as soon as practical. And the law now provides that you may require that the employee give you notice within a reasonable period of time. I don't think it's going to change much because of it. If it's an unforeseeable leave, um, uh, I think as soon as practical is probably going to be the same as reasonably required by the employer. Oh, and then the last piece on the changes for earned sick and safe time that take effect January 1st that you're going to want to have on your radar is there's a provision in the state law that says an employer may not require as a condition that an employee using earned sick and safe time find a replacement worker to cover those hours. And then they added a provision that says, however, this section does not prohibit an employee from voluntarily seeking or trading shifts with a replacement worker to cover the hours the employee uses as earned sick and safe time. And so how this law is interpreted could be concerning because it seems to imply that the employee can trade a shift with the replacement worker. And what if you don't want that employee to trade a shift with a replacement worker? What happens in that scenario? I mean, you may not want the employees trading shifts for a variety of reasons, including skill set or how they're able to relate to certain customers or what have you. And this provision seems to imply that those considerations don't count. But again, brand new law, how it's going to be interpreted, who knows? So I had a client on Tuesday call me a Debbie Downer. I didn't want to end with the bad news, but there are a few things that beyond paid family medical that you'll have to prepare for by January 1st.
Excellent. Well, we'll be meeting a few more times before then. So hopefully you'll have better, not so downer news to share, but
The government.
Yeah, and by the way, just because my name is Revnew, I am not related to the Internal Revenue Service.
That is good news for us, but thank you everybody for joining today. We did record this, so we will be sending out the recording to you. And maybe Tom can send me the slides and I'll send that as a PDF out to you as well. And hopefully y'all enjoy this next month and a safe 4th of July timing, vacations, etc. And we'll see you hopefully on July 24th.
Thank you.
Thank you.
All right. Thank you. Everybody have a great day.
Thanks, Chris. Bye.
Thanks.